So welcome to our 12 o'clock lunch and learn session of today's virtual learning exchange. And today we're going to be talking and hearing a presentation on ending a fixed term tenancy under special circumstances by Audrey Panter from the Residential Tenancy Branch. So Audrey Panter has worked with the Residential Tenancy Branch since 2013 and has worked in the area of policy and legislation with the provincial government for over 15 years. Audrey's interest in social policy and social justice is long-standing. Within the provincial government, she has led work on issues related to housing, supports for vulnerable children and youth, and as well as families, cross-ministry collaboration, inclusive communities, and the impact of public policy on affected individuals and groups. Prior to entering government, Audrey worked in residential settings with youth in care and adults with developmental disabilities, as well as volunteered for 10 years as a victim service worker with the Vancouver Police Department. So I'd like to welcome Audrey as our next webinar presenter.
Hi everybody, thanks for having me here. I'm going to be presenting some information, as was mentioned, on ending fixed-term tenancies in special circumstances. So you're going to see some slides and then we'll have questions and answer time at the end. All right, so we'll go into the first slide. All right, so on December 5th in 2016, just last year, legislative changes were brought into force that revised the Residential Tenancy Act to allow a tenant to end their fixed-term tenancy early and without financial penalty in a couple of specific circumstances: when they're fleeing family violence or when they're moving into long-term care. So you may be aware that a fixed-term tenancy is also known as a lease, and that basically is a tenancy agreement where a tenant is agreeing to rent a unit or property for a set period of time. Typically it's a year, and there are very limited circumstances under which the tenant or the landlord can end a fixed-term tenancy early without incurring some financial penalties. When we were looking at developing an approach here, we consulted extensively to determine the best approach to supporting tenants who need to end their leases early in order to flee family violence or move into long-term care, and to identify a process for determining a tenant's eligibility to end their lease, one that would have some rigor. We consulted with numerous stakeholders in the anti-violence sector to better understand the range of service providers who would potentially be providing support experiencing family violence, and that's where settlement workers came up. And we also consulted with the health sector to determine appropriate verifiers for those tenants who require long-term care. Next. So our goal in looking at this issue initially was that we wanted to make sure that we balance the needs and interests of both landlords and tenants. We wanted to ensure that tenancy laws support people who are fleeing family violence and those accepted or admitted into long-term care by removing a potential financial barrier associated with ending a lease early. Our goal also was to develop a process that balanced the health and safety needs of vulnerable tenants with the needs of landlords to have a process that reduces the likelihood of misuse. Next. All right, so in terms of who is eligible to end their fixed-term tenancy early, so as you see on the slide here, Section 45.1 of the Residential Tenancy Act is what sets out the eligibility. So a tenant is eligible to end their fixed-term tenancy if they have a statement that's made, and you'll find out more about this, it's by a third-party verifier, but this statement needs to confirm one of the following. One of the criteria is that if the tenant remains in the rental unit, the safety or security of either that tenant or a dependent of that tenant who lives in the rental unit is or is likely at risk from family violence carried out by a family member of the tenant. Bit of a mouthful, but it basically means that they may be experiencing violence or they may be at significant risk of it if they stay in there. So it could be their safety or security or that of children. So that's one of the criteria. Another criteria is that a tenant has been assessed as requiring long-term care. The third is that a tenant has been admitted to a long-term care facility. So these are three distinct criteria. So the family violence is obviously separate from the long-term care. Next. Well, in terms of who is eligible, so as I read you that definition of the tenant being at risk of or experiencing family violence carried out by a family member, the definitions of both family violence and family member are as defined in the Family Law Act. So in terms of family member, this would include a person's spouse or a former spouse, someone they're living with or have lived with in a marriage-like relationship, a parent or guardian of their child, could be a person that they live with it could be a person that they live with who is related to them or to their spouse. It could also be the person's child or a child that's living with another guardian. So it's the definitions of the Family Law Act that you'll want to refer. And in terms of long-term care, those who are eligible would be somebody who's not expected to be able to return to living independently under a tenancy agreement. Okay, next. So how does this work? How does the tenant end their fixed-term tenancy early if they require long-term care or need to leave due to family violence? Well, first they have to have their eligibility confirmed by an authorized third-party verifier. And then we have a particular form for that, which is called the Ending Fixed-Term Tenancy Confirmation Statement Form. A copy of that is up on the screen here. So the tenant, once that form is completed by the third-party verifier, the tenant gives their landlord 1 month written notice to end the tenancy, along with a copy of this, not a copy, the original of this completed and signed form. So in order for the tenancy to end, both of those things need to be done. They need to give 1 month's notice, and they need to give this completed and signed form. So that will effectively end the tenancy at the end of that 1 month period. The tenants are responsible for paying the rent until the end of that notice period, but they're not responsible for any additional months of rent. The tenant who ends the tenancy agreement is no longer responsible for any additional month's rent or for any of the landlord's costs to re-rent the unit. Where this is important is that when a lease is ended early, typically under other circumstances where it's not authorized under the Act, typically the tenant will have to pay the landlord's cost of re-renting, which might be in a liquidated damages clause in the tenancy agreement, and they also are liable for any additional months of rent that are left remaining in the agreement. So what this third-party verification statement and the ability to end under these circumstances does is frees the tenant from that financial liability. They're not required to have to stay, and they're not required to have to go through this process if they want to leave the tenancy. It just allows them to do so without any financial barriers. So the last point on that is that the tenant is not required to remain in the rental unit. So they don't have to stay till the end of that month. They could have already left prior to giving this notice. Next. So who is a third-party verifier? Who can complete this verification statement for eligibility? The legislation only allows certain professionals to verify a tenant's eligibility. Those third-party verifiers are listed in the residential tenancy regulation. There's 2 sections in the regulation. Section 39 lists the service providers and professionals who can confirm eligibility for family violence, and Section 40 of the regulation is the list of those who can provide confirmation of eligibility for somebody needing to move into long-term care. In terms of the service providers who can verify a tenant's eligibility due to family violence, it's quite a broad list of service providers, and we wanted to make sure that anyone who was in a professional capacity who would be supporting an individual who may experience family violence and who essentially we wanted to make sure that it was the community who was supporting them, not government making a determination. So we wanted to make sure there was quite a breadth. So the service providers who can verify for family violence include transition house workers, shelter and outreach workers, stopping the violence counselors, employees of victim service programs, victim court support caseworkers or settlement workers, physicians and nurses, registered social workers, registered clinical counselors, police officers, lawyers, Aboriginal service providers, and there are a few more listed in the regulation, but that gives you a sense of the breadth of it. In terms of the third-party verifiers who can verify a tenant's eligibility to end their tenancy to move into long-term care, it's more limited. It's medical practitioners, health authority case managers, and long-term care facility managers. Okay, next. What is required of verifiers? Well, the legislation, the Residential Tenancy Act, is what sets out the requirements of third-party verifiers. So when confirming a tenant's eligibility, a third-party verifier is expected to be authorized under the regulation to make the confirmation statement. So their profession needs to be one that's listed in that regulation, or they're not authorized to be able to do it. They need to assess the tenant and the tenant's circumstances in accordance with the regulations. So what this means is the regulation notes that in making a confirmation statement by a third-party verifier, it must be based on the standards of their profession or the generally accepted practices of their professional role and relevant knowledge and professional judgment. A third-party verifier must use that approved form, the Ending Fixed-Term Tenancy Confirmation Statement form, also known as RTB 49. That must be completed in full, signed, and include contact information for the third-party verifier. Now that could be the third-party verifier themselves or an authorized representative from their agency. That confirmation statement form, its contents, and the tenant's circumstances must be kept confidential. The confirmation statement form can only be provided to the tenant or to a person who's authorized to receive it on their behalf. And the regulation sets out who those individuals might be in Section 42. And then finally, you need to keep a copy of the form and any related records. Next. So how long is a verified ending fixed-term tenancy confirmation statement form valid? So this confirmation statement form, once completed, is valid from the date it's signed by the third-party verifier and for 90 days for the purpose of providing notice to end a tenancy for family violence, for 180 days purpose of providing notice to end a tenancy to move into long-term care. Next. So what happens if there's a tenant in the unit? So by ending the tenancy, one tenant who's on the tenancy agreement can end the tenancy, and what it effectively does, it ends it for all of the tenants who are on the tenancy agreement. So this is an important factor to consider. It's the case with any tenancy agreements where there's multiple tenants on it. One can end it, and it ends for all. Contract law. So in this circumstance, unless the remaining tenants enter into a new tenancy agreement with the landlord, they're going to need to vacate the rental unit when it ends. So they can enter into a new agreement with the landlord, or the landlord can choose not to. Next. So the question that comes up is, who tells that other tenant in the unit? Well, the tenant who gave the notice is not required to inform the other tenants that the tenancy is ending. This is particularly important for tenants who are fleeing family violence. It's well known that at the end of the relationship where there's violence, often the violence can increase, and it's a very risky time, so that's certainly not the expectation that the tenant will inform other tenants. In the case of long-term care, or if there aren't imminent safety concerns, then that is an option for them, but there is not a requirement that they do that. And while it's not a requirement that the landlord inform the other tenants that the tenancy is ending, it's a good idea for them to discuss it with the remaining tenants so that the other tenants can prepare to move and the landlord can look for new tenants. Also, the tenant could inform the remaining tenants that they could enter into a new agreement with them, or they have to just tell them when they have to move out. Next. So we've got that contact information on the form. Can the landlord call to verify it, that the form was completed by the person that has done so? So landlords and property managers may contact a third-party verifier listed as a contact on the ending fixed-term tenancy confirmation statement. And they can do so to confirm that the form was completed by an authorized person. Tenant's privacy must be maintained, so the landlord may only be provided with confirmation that the person who signed the RTB 49 form is authorized under the regulations to do so, and that is their signature on the form. A landlord cannot dispute the tenant's notice to end the tenancy if their claim is with respect to whether or not the tenant was eligible to end the tenancy. So for example, a landlord cannot claim that the tenant is not a victim of family violence. A landlord can dispute the tenant's notice if their claim is that the person who signed the form was not an authorized third-party verifier under the regulations. A landlord may also dispute the notice if it's not in compliance with the notice requirements of the legislation. So for instance, if that verifier form is not attached, then it would not be a legal notice to end tenancy. Next. So it's very important that it's recognized that this is confidential, and particularly due to the safety risks for people fleeing family violence. This was quite a concern that was raised through our consultations, and we wanted to ensure that confidentiality was addressed. So one of the questions was, does a landlord need to keep the confirmation statement form confidential? Yes, absolutely. The landlord, property managers, and third-party verifiers must keep the details of the form confidential and cannot share them with anyone, including other tenants. This is a legal requirement that is set out in the Residential Tenancy Act to ensure the privacy and safety of the tenant and of the third-party verifier. Landlords must also adhere to the privacy rules contained in the Personal Information Protection Act. Under that act, a landlord must refuse to provide access to a tenant's personal information if it would threaten someone's life or security, if it would reveal someone else's personal information, or if it would reveal the identity of someone who provided personal information about someone else. Unauthorized use or disclosure may subject the landlord to an investigation by the Office of the Information and Privacy Commissioner. Next. So our website, newly revamped website and then also updated in December with this, has a lot of good information. It has our act and regulations, examples of hearing decisions. It also has a lot of tools for you to use, like videos that explain important tenancy topics, calculators that help you determine things like how much rent can be increased this year, and quick tips. If you use Facebook, Twitter, or YouTube, we encourage you to follow the BC government accounts to keep up with residential tenancy updates and new tools. So on our website, we encourage you to take a look at that. We have good information about these changes, and there's also a really good video that is specific to this topic of ending fixed-term tenancies in special circumstances that I believe will be links sent out to you, and that's a really good one to get another overview of what I talked about and perhaps even to share with clients that you might be working with. All right, next. So this concludes my portion of the presentation. I wanted to thank you for the opportunity to present. I'm going to hand this session over now to questions and answers. So I will be able to answer any questions you might have, and I'll just pass it over to Leslie to give you information on that.
Thank you so much, Audrey. And so please feel free to send in your questions using by typing them into the chat box, by tweeting them to AMSA using the hashtag AMSA events, or by emailing them to events@amsa.org. We do have a few questions already. And so one of the questions that came is if you could please expand on who is an eligible third-party verifier, and how can you be certain that somebody is eligible to be that verifier?
Well, I would encourage you to take a look at the regulations because the list is quite extensive. So in terms of family violence, it's going to be a very large range of people, from a police officer who might be attending to a social worker, a registered counselor. It could be a huge range. We wanted to make sure that we were going to capture all of those service providers who might be involved with somebody who would potentially be sharing with them their experience of family violence and who would be able to provide some rigor to this process, keeping in mind that it's not an expectation of that specific person to complete the form if they don't feel that they have the information, knowledge about violence to be able to do that, then they can refer them to another service provider. What was the second part of the question? My apologies, I lost the second part of the question.
So the second part of the question is more how can an individual be certain that that person is an eligible third-party verifier who they're using?
So the tenant, how can they be certain?
Yes.
Or well, typically the information is on our website. It really is up to the person who's the third-party verifier to ensure that they're eligible. The tenant, we envision this would be part of a conversation that would happen. So it's not necessarily that a tenant is going to come in the door of a service provider and say, I've got this form, I want you to fill it out. But it may be through the course of working with a tenant that the service provider learns that there is this risk there and that it would probably be part of their plan to move out of that situation. So the tenant can get that information from our website. Third-party verifiers can get that information from our website and from the form, but really it's up to the third-party verifier because they're signing the form to make sure that they are one who's authorized to do it.
Okay, thank you. Another question that came up as a follow-up to that is, could you clarify if settlement service providing agencies are eligible third-party verifiers?
Yes, yes. I should have had the wording in front of me, but it's basically any, I believe it's provincially or federally funded service providers who provide settlement services. I should have had that in front of me here. But yes, it's very clear. We worked with both the provincial contact and federal contact to make sure that anybody who works in the settlement work capacity is authorized.
Okay, thank you. And do settlement organizations, do they need to register as a third-party verifier, or is that kind of something that's automatic?
It's because it's listed in the regulation. The professionals just need to make sure that their profession is listed in there. There's no centralized system. It's basically that they see that they are listed there, and then they have full authority to be able to complete the form confirming the tenant's eligibility. So we're not checking it. There's no central register. There's nothing. They just need to ensure that they feel that they have the adequate knowledge and skills to verify the eligibility. And it's not, they don't have to be doing safety planning or anything, risk assessment specifically. It's really that they can verify that that tenant meets that particular eligibility as listed in the legislation.
Okay, and another question that came with that is, are there fees associated with that, completing that form and using a third-party verifier?
There may be a doctor, for instance, who charges to fill out forms, but we haven't set any fees on it. It would be up to any of the bodies that would be completing them. So it would be entirely whether they charge fees to complete forms. It's on our website. Anyone can download it. Anyone can fill it out. So it's really only if that's part of their policy in having forms completed for someone.
Okay, thank you so much. And another question that came was, after signing the ending of the fixed-term tenancy agreement, Are tenants still responsible to cover any possible liquidated damages and rental loss due to the early ending of the lease?
No, they're not. So the liquidated damages is the one of those financial penalties that we have removed by allowing this to have to be ended early. So if under other circumstances, yes, they're responsible for the liquidated damages, which are essentially the landlord's cost to re-rent the unit, and under other circumstances would be responsible for paying rent up until the end of the term or until the landlord can find a new tenant. But what these changes do is for these particular circumstances, they are not responsible for that. So once that tenancy ends or once they've given the notice, they are only responsible for the month rent payment until the end of tenancy takes effect, and they're not responsible for anything going forward. The landlord could potentially claim for if there were damages or things like that that incurred during the tenancy, but in terms of the costs associated with ending the tenancy early, that is the purpose of this change. It does not require them to be in any way liable for that.
Okay, thank you so much. And are tenants who end their tenancy early, are they eligible to receive their damage deposit back?
Well, they could. So that would have to be done in accordance with the legislation, which requires that the tenant provide a forwarding address to the landlord within a year of ending the tenancy, and then the landlord must provide the security deposit back within 14 days if they haven't disputed. Now, this is a consideration as well if there are more than one tenant on the tenancy agreement, because legally they would both be entitled to that security deposit. So again, that's one of those conversations with the tenant in terms of, you know, is it, do they want to have that back? Do they want to potentially be in a dispute resolution with the person that was perpetrating violence? They could choose to leave the security deposit with the landlord in case the person that they are leaving causes damage to the unit. So they are entitled to it, yes. It's part of the conversation as to whether they want to be providing the forwarding address and having that returned to them.
Okay, thank you so much for explaining that. Audrey, the other question that came up, if a landlord does disclose a private information in the form, as you mentioned, how would the investigation be triggered? Would the client be required to bring forward a complaint?
Somebody would need to bring that to attention of the Office of the Information and Privacy Commissioner.
Okay.
Yeah, it's their office that has the authority to investigate. So unless somebody has brought it to their attention, then they wouldn't know that breach had happened. And then it would be, of course, up to their process and their how they handle that in terms of what would happen going forward. But we're also hoping by having, loud and clear on the forms everywhere that this is a potential consequence and that the information does have to be kept confidential. It was a concern that was raised, and it's also recognized it's potentially more challenging in smaller communities, and so there's no surefire way of being able to prevent somebody from doing it, but there is that potential consequence for it. But again, somebody has to bring it to the attention of that office.
Thank you so much. And another question that has come forward is, for settlement workers whose client is facing family violence, what steps can that settlement worker do to assist the client in ending the tenancy early?
Well, they could use that verification form, the ending fixed-term tenancy confirmation statement form. That is one thing that they can do, but certainly a really important part would be connecting the tenant to other resources. There's a significant amount of resources for people who are experiencing domestic violence, family violence. We have links on our website to that, so it really would be important for that person to have a support network around them as well. So that allows for the third-party verifier or the settlement worker, if they didn't feel comfortable completing that form, to connect them with somebody who could. But also, it's very, very important that they have that support because it's such a difficult time and a difficult experience that there are a lot of really well-trained anti-violence workers, programs that are funded by the Ministry of Public Safety and Solicitor General, Stopping the Violence counselors, children who witness violence counseling programs that would really be a benefit. So part of this is an opportunity to be able to connect people to those other resources that really can help them with those violence issues.
Okay, thank you so much. And what supports are available for clients or for tenants with low literacy skills or low language levels?
In terms of this process?
Yes.
Or well, we haven't got anything set up, but I would expect that using some community-based service providers who would be able to support them in their language. We haven't got anything established in that way. I know that some of our information officers do speak other languages, but they can't really advise on how to do the form. They can provide the information about the process, but I would expect that they would need to connect with community or say family members who could assist with that.
And where can clients get these forms that are needed? Are they
all on our website?
Online?
Yeah, everything's on our website. So, or Service BC offices. Yeah, so if they don't have internet access, Service BC offices, our residential tenancy branch office in Burnaby.
Okay, thank you so much. And could you maybe clarify and explain the eligibility to confirm risk of family violence?
Okay, so the eligibility to confirm the risk. So what the actual what the eligibility criteria is for family violence?
Yes.
All right, I'm just going to grab my notes. It's worded in a particular way in the legislation, so it can be a little bit of a mouthful. So I'm going to read it out slowly just so you can hear the nuances of it. So it's, if the tenant remains in the rental unit, the safety or security of either the tenant or a dependent of the tenant who lives in the rental unit is or is likely at risk from family violence carried out by a family member of the tenant. So key parts of that are if the tenant remains in the rental unit. Again, they could have already left, but it would not be safe for them to be going back. So their safety or security of either them or one of their dependents or any dependents who live in the unit is at risk or is likely at risk from family violence carried out by a family member. So we didn't want to just be dealing with those who were experiencing family violence, but there was a risk of it as well. And that is in the legislation as well as listed on our website.
Okay, and going back to the third-party verifier, you mentioned that settlement organizations are eligible to be that third-party verifier. Does it have to be within the organization? Is it up to each organization who is eligible, which staff member is eligible to sign the paperwork, or is anyone who works in those agencies eligible to be that third-party verifier?
It should, the person who's actually signing the form saying, I'm confirming this tenant is eligible, really should be the person who's been able to make that determination, so who's worked with, who's assessed the tenant and can say, yes, based on my professional knowledge, etc., I am confirming that this person is eligible. In terms of the contact person, that could be somebody else in the organization. So that's, again, if the landlord calls and says, I want to confirm that, so-and-so who signed this form here, do they work for your agency? So that can be a different person, but the person who actually is signing the statement saying, I am making this statement confirming eligibility, needs to be the person who's worked with the client and is the one who's made that assessment that they're eligible.
Okay, and you also mentioned that it is up to the landlord when the rental agreement is ended, that it's up to the landlord if they decide to create a new rental agreement with any remaining individuals who were on that lease. to remain in the unit.
Mm-hmm.
When that occurs, is the landlord allowed to increase the rent or not?
Well, it would be a new tenancy. So with under our current legislation, it would be a new tenancy agreement. So speaking quickly off the top of my head, I would think yes.
Okay. So thank you so much for sharing your presentation today. You've answered all the questions that have so far have come in. So if anyone does have any more questions for Audrey, please type your questions into the chat box, tweet us using the hashtag AMSA events, or email them to events@amsa.org, and I'll just give it another minute or two just to see if any more questions do come in. And I haven't seen anything come in so far. So thank you so much, Audrey, for sharing. Today, and we will be taking a short break and coming back at 1 p.m. So thank you so much, Audrey.